Let's look at Federalist 84, Part 3. I stopped in the middle of the third paragraph. As we go forward, you'll see on your screen kind of a review of some of the materials that I have recommended to you. One of them is at the very beginning. Obviously, as you can see, I don't have there's no video quality in my videos. That's an understatement. So some of the videos that I think will be helpful for you to begin with is the PBS series, mini-series Liberty, PBS television series Liberty on the American Revolution. And then History Channel has 3 sets of videos regarding the American Revolution and the founding of the United States. They're all accessible, they're pretty good. So if you can, definitely start with PBS's miniseries Liberty and go forward. So I will start somewhere in the middle of paragraph 3 where I left off. Article 3, it says, in the middle of that, it says, Article 3, Section 2, Clause 3, the trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Section 3 of the same article, treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. And Clause 3 of the same section, the Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. So even in case of treason and high crimes, you don't go kill the person's brother, sister, kids. That's what he's talking about, corruption of blood or forfeiture. You don't go get the family's belongings. You can get the person that's responsible, punish them, but that's it. And then it defines what treason is. It just doesn't leave it to, let's say, to presidents or the judge's whim, whatever they decide the president is. The treason is. So as we talked about earlier in parts 1 and 2 of this Federalist, Hamilton is talking about what he says miscellaneous issues, the various issues that he'd left out in the last 83 papers, or he had not put in the right category, he says. And the first thing that he's trying to address is all those criticisms that this Constitution has no Bill of Rights. And he's listing all the things in the provisions in the Constitution that he thinks are just Bill of Rights, as good as Bill of Rights. So he says, why are you guys complaining? And as I've already said, I think this is one part that he really made a mistake about. And luckily, with anti-Federalists putting pressure on the Federalists and saying that the only way we're going to ratify this Constitution is if you promise that in the first Congress, when the first Congress meets, you all put in a Bill of Rights there. And fortunately, Madison, after he realized that that's the only way he can do it, he guided through the first Congress the first 10 amendments to be added to the Constitution, the Bill of Rights. So Hamilton here is saying you really don't need a Bill of Rights because we've got these provisions. And as I've said before, he did have a bit of monarchical tendencies in him. And Hamilton, but to be fair to them, Hamilton and Madison really did not want to have another convention before the ratification of this Constitution. And they did not want to have another convention for amendments to the Constitution. So finally they came around and they realized that there's no way around this issue. They have to have a Bill of Rights. And throughout all this, Federalist Hamilton declines that. He says, we don't need it. We don't need it. The next paragraph, paragraph 4, it may well be a question whether these are not upon the whole of equal importance with any which are to be found in the Constitution of this state. This state. The establishment of the writ of habeas corpus, the prohibition of ex post facto laws, and of titles of nobility, to which we have no corresponding provisions in our Constitution. He says some of these stuff that we have in the federal constitutions, we don't even have in our New York Constitution, are perhaps greater securities to liberty and republicanism than any it contains. The creation of crimes after the commission of the fact, or in other words, the subjecting of men to punishment for things which, when they were done, were breaches of no law, and the practice of arbitrary imprisonments, have been in all ages the favorite and most formidable instruments of tyranny. Pretty much he says ex post facto laws, the establishment of writ of habeas corpus, not having titles of nobility, these are some of the best guarantees you can have that you have a Bill of Rights, that you're already dealing with a Bill of Rights. The observations of the judicious Blackstone, because Blackstone is the famous jurist, British jurist, who'd written the commentaries on the laws of England, in reference to the latter, are well worthy of recital. To bereave a man, he's quoting Blackstone, to bereave a man of life, says he, or by violence to confiscate his estate without accusation or trial, would be so gross and notorious an act of despotism as must at once convey the alarm of tyranny throughout the whole nation. But confinement of the person by secretly harrying him to gaol, where his sufferings are unknown or forgotten, is a less public, less striking, and therefore a more dangerous engine of arbitrary government. So he's talking about the ex post facto law, stuff like that being horrible. But he says even worse than that is if we don't respect the writ of habeas corpus, which he says taking somebody to the dungeon or somebody to prison without them having to be able to see what the charges are against them, without standing in front of a judge, defending themselves. He says this is the worst thing. And that's why Hamilton keeps on saying, well, we have a Bill of Rights in the body of the Constitution. Why are you all asking for a Bill of Rights? Look, even Blackstone says the part that we put in the Constitution is wonderful. We'll continue. Nothing need be said to illustrate the importance of the prohibition of the titles of nobility. This may truly be denominated the cornerstone of Republican government. For so long as they are excluded, there can never be serious danger that the government will be any other than that of the people. To the second, that is, to the pretended establishment of the common and statute law by the Constitution, he says, to the second criticism that they have of us, I answer that they are expressly made subject to such alterations and provisions as the legislature shall from time to time make concerning the same. They are therefore at any moment liable to repeal by the ordinary legislative power, and of course have no constitutional sanction. The only use of the Declaration was to recognize the ancient law and to remove doubts which might have been occasioned by the Revolution. This consequently can be considered as no part of a Declaration of Rights, which under our constitutions must be intended as limitations of the power of the government itself. So when we come back, we'll continue with the rest of Federalist 84. He makes some references to British history, which, as I have told you before, it is good if you don't have a chance to read a book on the British history. Just look at some of those really good documentaries about Britain, British history. They're available online. Gives you some sort of foundation for knowing what Americans had experienced, had known about their so-called mother country and the experience of Britain over the centuries, and what they learned from it, and what traditions they borrowed and kept, what traditions they did away with. Remember, I said earlier, one of the great things that Americans did, they did away with the law of primogeniture. That's when the first son inherits all the state, all the land, all the property. And this way they can keep the family as with a title of lord or baron or whatever, but and they could actually afford to do that because it worked in England because the land was so small. But in the United States, plenty of land. You're not going to need that. So that was a good fortune of us, a fortune of ours, that they did away with that law of primogeniture, and we did not get any titles of nobility or anything allowed in this country.